my paper, and you're lucky you weren't in.
Yes. Did you get a call from a David K? He had called you weren't your land. I gave him the open name because he didn't know if he wanted a man or a woman.
Charlie Chang.
Yes, yes, he's coming in to see me.
His English is
I know.
Okay,
Time flies.
we're good.
Take care.
Yeah.
Good morning, everyone. My name is Helen Bernstein. I'm Counsel Program Development at the Law Society. I want to welcome everybody to today's program, our 4th annual 6-Minute Criminal Defense Lawyer. We want to welcome everyone in the lecture hall in Toronto and also those watching and listening across our interactive learning network across the province. If you're attending at an ILN site, please take the time to help us by taking your name off the attendance list. We hope everyone takes some time to fill in the Great Course Evaluation form, and we encourage everyone to take a look at the criminal law specialist material. We have some folders with specialist information outside the lecture hall in Toronto on a table, just outside the left-hand door. And if you're at an ILN site, we encourage you to call the Law Society to inquire about criminal law specialist certification. We want to mention that the program is being videotaped. And finally, we want to thank our 2 chairs who've put a lot of effort into this program, Peter West and Andrea Tuck-Jackson, both of Cooper, Sandler, and West. They're both prominent members of the criminal law bar, and we want to thank all the members of the faculty as well for all their efforts in helping us with this program. I know you're in for an interesting day, and I'll turn the podium over to
Me.
Peter.
I want to welcome you to our 4th annual 6-Minute Criminal Lawyer. Just to let you know, we have people in Barrie, Burlington, Hamilton, Huntsville, Kenora, London, Niagara-on-the-Lake, Ottawa, Sault Ste. Marie, Sudbury, Thunder Bay, Waterloo, and Windsor, all watching what takes place here today. And we have speakers at 5 of those locations. So it's pretty exciting that we're involved with this ILN network. We're not going to be introducing the CVs of any of the speakers this morning. They are contained in your materials, so you can refer to those at a later point in time. There are papers provided. You can refer to those probably at a later point in time. I don't think the speakers have enough time to read their papers to cover. This is the 6-Minute Criminal Lawyer, so at the 6-minute mark, when you hear the buzzer go, your time is up, and everyone can start hissing and booing because they're supposed to sit down. Anyway, without any further ado, I'm going to turn things over to Hamilton, where we have Jeffrey Manishen. Jeff normally comes to Toronto because Hamilton is the city that it is, but he has another engagement this morning. I think he's going to the Shaw Festival, and so he wanted to speak first and wanted to speak from Hamilton. So without any further ado, you all know Jeff Manishen. I think we're in for a good 6-minute talk. Jeff, over to you.
Thank you, Peter. The talk that I had originally written was for a program called the 10-Minute Criminal Lawyer, but given the reduced scope of the preliminary inquiries, I've cut it down to 6. And while we can still do preliminary inquiries, it's a topic, frankly, I've always wanted to speak about because other than asking for a big enough retainer, it's probably the area of law that I do most poorly. So I thought I'm going to look at the various rules that I've drafted for myself for the conduct of preliminaries and share them with you. Now, I might say, though, that the idea of preparing rules for anything, it doesn't really count for a lot. It's like the talk that Roger Dodd gave once talking about Irving Younger's famous lecture on the 6 rules of cross-examination. And the last one was, never ask one question too many. And Dodd always said, well, that's a great rule. You can figure it out, but what do? You write out all your questions, and then you tear off your piece of paper with the last question at the bottom. Now you say, well, I don't need to worry about that rule. But the problem is that although you might learn the rule and remember it, applying it is much tougher. So I'll share with you the rules that I try and teach myself and try and apply for every preliminary inquiry. One of them, remember the purpose of the exercise. If what you're doing is challenging committal, well, then it may be a more minimalist preliminary inquiry. You may not be asking as many questions because you don't really want to expand the scope of the case for the Crown. beyond what the Crown leads. And so you realize that you might be giving up a fuller preliminary inquiry, but the idea of it still is, the purpose is you're challenging committal. You don't want to explore areas that might enhance the case for the Crown. On the other hand, a lot of the time, far more often I'd say, we're looking to develop the foundation for what we're going to do at trial. And the exercise in that regard for the proper conduct of a preliminary, the phrase I use, and I've got a number of, shall we say, 3 or 4 word phrases that I use as a kind of reminder. I call it learn without teaching. You want to learn as much as you can about the case for the prosecution without teaching the Crown, the police, and particularly the witness where you're coming from, what your strengths and weaknesses are, what the approaches are that you'd like to be able to use at trial. You're going to have to roll some of those cards, but you want to try and keep that to a minimum. In addition, a rule that I try and apply all the time, I think of a preliminary inquiry as the first act of a 3-act play. And the second act is the Crown's case at trial. And the third act is the defense evidence and your final argument. So things that are going to be developed in Act 3, you have to set the table for in Act 1. You really have to think of the full picture and where the first part of the proceedings really fits in. And so in that regard, preparation is essential for a preliminary inquiry. I'm sure a lot of times Crowns don't think of it as preparation for trial. It's just a prelim. And I'll bet there's some defense counsel that do the same. That's not the way to approach it. You have to have the materials all prepared, summarized, compared and contrasted. If there are different statements by one of the witnesses or compare one to another, you've got to spend a lot of time on the theory of the defense so you have it fully realized as best as you can for that stage of the proceedings. And obviously you're going to test out some of the features of it as you might go. It's worthwhile as well to know the defense evidence that you've got available. Not with the view of in any way disclosing what you have, but again, setting the table, laying the foundation. I think of a preliminary inquiry a little bit like exploratory surgery. If you were going into a dentist's office and he was going to be testing and probing and poking like the movie Marathon Man. Is it safe? You might want to ask yourself as you explore things with questions. But you can try and get the witness off the script. You may want to get into exploring the interview process by which the witness ultimately came to share his or her story. You might want to explore the witness's emotional state and history. You might want to find out if the witness has told any of this information to other people and who they are. Because this information might not be in the disclosure, and here's a great opportunity to develop areas that you might ultimately use at trial. I'd say that at a preliminary inquiry, you have more license to ask open-ended questions, because to some extent it's information gathering. On the other hand, once you've covered an area, a phrase that I learned, I think, years ago in trust law, and I don't understand it anymore, but Professor Peter Hogg used to say, this will trigger the class closing rules. I think of class closing rules for a preliminary inquiry as, is that all that you can tell us with respect to your physical contact with the accused? Is that everything the accused said to you? Have we now covered it now? You might even want to summarize. You told us he did this, this, and this. Are those the only 3 things he ever did? And that way, when you're going to be proceeding a trial, if the witness changes the story, you have a great foundation that you have developed. It's a point of discussion that I've had with other lawyers. Do you ever want to ask why questions? Do you want to get into areas that you don't know the answer to? And some would say, good answers for the Crown will take note of and use at trial. My experience has been I've gotten lots of good, interesting information by asking questions that I didn't know the answer to at a prelim, but it's a judgment call for you. Remember, too, that you can use the preliminary, and really should, for the development of foundations in evidence for third-party record applications at trial, for charter applications at trial. There may be times when you'll want to run a voir dire as to voluntariness at a prelim, or at the very least have the Crown call the officers in that regard to develop that foundation.
Jeff.
But one of the pardon me?
A minute.
1 minute, thank you. One of the major things, rule in the breach, is you save your bombs. You do not do it like a trial cross. I make this mistake all the time. You get a little bit carried away. You say you've got the witness on the run. You pound away, and you've now taught them an area. They've learned more about you. So you save things for trial. You use restraint. Final concept, always think of the transcript. How is it going to read? If you're going to be using it at trial, it's going to be based on the words that you used, the phrasing, wording, questions, and answers, and that's a feature to keep in mind at all times for the effective conduct of a preliminary inquiry.
Thanks, Jeff.
Good morning, and we're going to bring things back to Toronto. I'm going to ask Rebecca Rutherford to come forward to talk about non-custodial sentences under the YCJA. Rebecca.
Thank you. Good morning. When it comes to sentencing a young person under the Youth Criminal Justice Act, you really have a lot of latitude to think outside the box. You really must think very differently when considering your submissions for a young person versus an adult. In determining the appropriate sentence for a young person, please be familiar with the purpose of sentencing under the YCJA. This is set out at section 38, subsection 1 of the Act. Your client, and I'm paraphrasing, your client must be held accountable by imposing just sanctions that have meaningful consequences and promote rehabilitation and reintegration into society. The Act goes on at section 38, subsection 2, to set out specific sentencing principles. The sentence must not be greater than what an adult would receive. There must be regional consistency, and I know we don't often see that. The proportionality of there must be proportionality to the seriousness of the offense and the degree of responsibility of your client. There is a priority to no jail. There must be particular attention to Aboriginal youth, and the sentence must be the least restrictive. The key words to remember, in my view, are accountable, meaningful consequences, rehabilitation, and least restrictive. Keeping these in mind, counsel can be quite creative in asking for non-custodial sentences for a variety of offenses, notwithstanding antecedents of your client. For example, one of the new non-custodial sentences under the YCJA is something called a judicial reprimand. It's found at section 42, subsection 2, subsection A of the Act. This is considered to be the most lenient of sentencing options. It could be a tongue lashing by a judge. It could be as little as hope to not see you again in court. The benefit of a reprimand is that the period of access to the youth record is only 2 months. However, just because a reprimand seems so lenient does not prevent counsel from asking for this sentence after a second, third, fourth, even fifth conviction. For example, if your client has already been sentenced in the past to probation, has been sentenced to jail, has been sentenced to community service, you may still have the grounds to argue that to impose these particular options would not be in keeping with the purpose of sentencing under the Act. That is, they would not be just sanctions that have meaningful consequences for your client. So even though your client may have a record, if now he or she is in school, is working, is in some form of therapy, is reunited with his or her family, it may be that to impose probation would be too restrictive. Therefore, in this case, you may be able to demonstrate that a judicial reprimand is the least restrictive sentence and in keeping with the purpose of sentencing under the Act. A lot of the time, judicial reprimands are ordered when there is just nothing else to do. Your client may come to court having completed volunteer work, written letters of apology, paid restitution. There really isn't more a court can do by way of rehabilitation. Therefore, a reprimand may be in order. But please keep in mind that reprimands are not reserved for minor offenses, so don't be afraid to ask for one. If you can demonstrate that the reprimand is a just sanction with a meaningful consequence to your client, that holds your client accountable and promotes his or her rehabilitation into the community, and it is the least restrictive sentence, then you really should go for it. And I've had a number of judges tell me that counsel aren't not using or not asking for judicial reprimands, so it's really important to consider that. Remember, when sentencing a young person, it is not a building block approach. That is, with each conviction comes a more serious penalty. If circumstances are such, and you can make an argument which meets the purpose and principles of the YCJA, do not be afraid to ask for any sentence you feel is appropriate. Other sentencing options to consider under the YCJA are something called an attendance order. This option requires a young person attend a non-residential program approved by the provincial director at specified times and on specified terms. The time limit is 240 hours over a period of up to 6 months. It's usually ordered when a young person has specific needs to be addressed. It's like one-stop shopping. At the particular facility, there would be one-on-one counseling, educational upgrading, access to counseling to deal with issues such as substance abuse, mental health issues, life skills counseling. There also may be assistance in housing. Am I there already?
1 minute.
There will also be, before a court can impose this order, the provincial director must determine that a program is available. For those of you that practice in Toronto, there are 2 attendance centers. One is Turning Point in the downtown area and Operation Springboard in Scarborough. This sentencing option is very useful because it's more intensive than a counseling condition in a probation order. Therefore, counsel can make an argument that to impose such an order is in keeping with the purpose and principles of sentencing, and you can probably keep your client out of jail. I know I have just a little bit of time. There is something in the Act called the ISSP that is not available in Ontario at this point, which is called the Intensive Support and Supervision Order. It's one step above an attendance center, but it's not available yet in Ontario. The last non-custodial sentence option is that of Deferred Custody and Supervision Order. It's like the Adult Conditional Sentence Order. It can only be imposed for 6 months, and there are particular conditions that the court can impose. You can see that with the addition of these new non-custodial sentencing options, counsel have a great deal of leeway to come up with particular plans that fit within the purpose and principles of sentencing. So don't be afraid to use them. Learn and understand the purpose and principles. Don't be afraid of prior antecedents that your client may have. All of these options are available. Don't think like you do when you're before a judge and sentencing an adult. It's something completely different, and there's lots of room for lots of new plans, and you can be as innovative as you can. Good luck.
I'm going to ask Anil Kapoor to come up and speak in Maureen Forrestal's place. It's a daunting task, Anil, but I know that you're up to it.
Yes, I'm here to talk to you about hearsay on behalf of the defense. This little talk is Maureen's talk delivered through hearsay, that is through me. It is necessary. I'm not sure how reliable it is. First of all, the basic proposition to keep in mind is that the rules of evidence apply equally to both the Crown and the defense.
No, setting it.
I'm tempted to say that it's racism in the system, but I won't. A good starting point for your assessment of generally admitting evidence on behalf of your client is a case called Watson, 1996, 108 CCC 3rd, 310, judgment of Justice Doherty. And basically, the bottom line of that decision, and it's at page 323, is that all relevant evidence is admissible. And relevance means that whether as a matter of human experience and logic, the existence of fact A makes the existence or non-existence of fact B more probable. Well, how does that affect hearsay and the admission of it? Well, in my view, the defense can lead hearsay for the truth of its contents, and the test for admission at the hands of the defense is slightly relaxed than it is at the hands of the Crown. And generally speaking, I think a compelling argument can be made that the rules of exclusion of evidence apply differently when it's defense evidence. And that is because the policy objectives for excluding evidence in the hands of the Crown are often very different and do not obtain when it's the defense that's leading the evidence. So for example, in the case of similar act evidence, when we seek to exclude evidence, or disposition evidence, when we as defense counsel seek to exclude evidence at the hands of the Crown, we're concerned that our client is going to be judged by his prior acts to be a criminal on the act for which he's charged. Well, that doesn't apply when the defense is seeking to lead evidence, which could arguably be similar act evidence. That is, that the accused has acted in a particular way in a previous circumstance that ought to inform your view of how the accused acted in the charged circumstance. And a good case that sets that out is the decision of Justice First in Morrissey, which is cited in the material that you have from Maureen. In Morrissey, Justice First concluded that the defense could lead evidence of how the accused would act in previous circumstances where a relationship is broken up to determine whether or not the accused in the charged instance, which was a first-degree murder, had the homicidal intent or whether his intent was to commit suicide, shot himself, and shot his wife. So you have to ask yourself, whenever you're going to lead evidence, whether any exclusionary rule has any application at all to your circumstance. Why is it that the hearsay rules are relaxed somewhat for the defense? Well, the notion of the prejudice from the admission of hearsay just doesn't apply in the same way that it applies when the Crown seeks to lead the evidence. The accused, of course, there's no risk of a wrongful conviction by the admission of hearsay. And if the Crown has led hearsay evidence for the truth of its contents, you may be able to lead it even though you cannot strictly meet the test. And in that sense, I'd like to take you or give you 3 sites where that happened. The first I'd like to give you, this is not in the paper, is a case called Underwood, 2002, 170 CCC 3rd 500, and shock of shock from the Alberta Court of Appeal. Paragraph 58. In that case, the court concluded that there is no prejudice to the Crown in having the statements admitted. The Crown's overriding interest was not in convicting the accused, it was instead to find the true identity of Campbell's killer. The Crown could hardly be prejudiced by the admission of evidence pointing to someone other than the accused as the murderer. The evidence at issue there was a hearsay statement. There was some question as to whether or not the accused could establish reliability. The Court of Appeal said it ought to have been admitted and sent it back for a new trial. Another case is Miller, which is from our Court of Appeal. It's an older case, 1991, 68 CCC 3rd 517, at page 534. Our Court of Appeal says, here it is the accused rather than the Crown who wishes the hearsay evidence to be admitted. It is not only in his interest to allow the admission of the evidence, but its admission also balances the admission of hearsay evidence at the behest of the Crown to show the frame of mind of the deceased. So in that circumstance, the Court of Appeal says, well, trial judge, if you've admitted the evidence for the Crown, you may want to relax the rules to allow the defense to lead some evidence to balance it. And the last one I'll give you is Drover, D-R-O-V-E-R, 2000, Newfoundland Judgments, number 36, paragraph 28, where the court, that's the Newfoundland Court of Appeal, says, in this case, it was the accused who sought the admission of the statement to assist in his defense. Arguably, in such a case, the reliability threshold should be lower than that required when it is the Crown who seeks admission of a statement in like circumstances in establishing guilt. At the end of the day, in my respectful view, I think that what you should be doing is not shying away from trying to have hearsay evidence admitted if you think it will assist your client. And it can be admitted in a number of different ways, not only through you tendering the evidence, but also through your cross-examination of Crown witnesses. You may choose during your cross-examination to get a ruling for its admission, or if it can be admitted for the not the truth purpose, that is the non-hearsay purpose, at the end of your trial, if you think it's helpful, you can ask that it be considered for the truth of its contents. Once the trial judge has heard all the evidence and you have a sense of the Crown's offering of proof as it has gone in. So I hope that is of some assistance. It's not exactly Marine Forestall, but hopefully you will be kind. Thank you very much.
Thank you, Anil. Next, I'm going to ask Greg LaFontaine to come forward to talk about the Bennett decision, a decision that's near and dear to my heart as I had to rely upon it in a murder case on the Monday immediately following the Friday of its release. Greg.
Thank you very much. My paper is stuck into the front of the binder. Last year when I stood up, I made a joke. When my paper was stuck in the front of the binder, I thought that this was the last-minute criminal defense lawyer. This is the second annual last-minute criminal defense lawyer. Bennett is a case about the analysis of trace evidence of hair, something that I and one of the introducers, Peter West, highly qualified to deal with, both having trace evidence of hair.
Speak for yourself.
In the 5.5 minutes that I have left, I'll tell you about everything there is to know about Regina and Bennett. For starters, it's a decision of the Ontario Court of Appeal that was released on October the 3rd, 2003. It happens to be 159 paragraphs long, not counting the footnotes, and fills 50 pages of a volume of the Canadian criminal cases, including many, many pages that delve into highly complicated, very dense scientific issues. So in the remaining 5 minutes that I have, I will not attempt to meet the task of providing a comprehensive analysis of the case. We'll save that for the 6-hour criminal defense lawyer. But we'll attempt to hit a few of the high points and leave you with the suggestion that you read it yourselves. It's a strong suggestion because, in my view, it is required reading. Milton Bennett was tried about 1.5 years after the Kaufman Commission report into the proceedings against Guy Paul Moran was released. However, after reading the decision of the Ontario Court of Appeal in Bennett, you are left to be concerned whether or not the Commission report had any real impact on the prosecution of this sort of a case. The first lesson from Bennett is that in terms of the types of evidence that were called and the arguments that were made to sort of stretch forensic expert evidence way past its possible permissible uses, the case was prosecuted in a manner that showed that the defense bar cannot depend on the Crown to simply give up on trying to tender this sort of evidence without a fight. I will use the phrase "without a fight" to segue into lesson 2, because at Bennett's trial, despite no doubt good intentions, there were clear failures to object to some of the scientific evidence, and far too much of the scientific evidence was conceded as being admissible. The defense bar must become better educated about the limits of the science in issue being relied upon by the Crown in order to confront whether or not that evidence has any real probative value. Lesson 3 is that trial judges will not act as gatekeepers, as the Moran report suggests they ought to keep out dangerous evidence on their own motion. They should not be expected to, first because our system depends on parties raising issues of admissibility, and number 2, because of the natural inclination to not keep anything or hide anything from a jury, particularly in cases that depend on circumstantial evidence. The defense must push the trial judge to exclude this sort of evidence. In both Bennett and another recent hair-raiser from the Court of Appeal called Regina and Portillo, the appeals judgments are not nearly as useful as precedents for the defense bar as they would have been had all of the issues been litigated at trial. In both cases, hair and fiber evidence of dodgy quality and usefulness ended up before the jury without being fully litigated. The job of the defense bar in the next few years will, in my view, be pivotal in determining what is the appearance of post-Moran criminal trials in the next few years. And the defense bar has the responsibility to raise the right arguments whenever necessary. There are two guiding principles that I think can be distilled from the Bennett case that can apply pretty much to most types of scientific evidence and a variety of other sorts of evidence. Number one, if the evidence shows only a similarity as between the perpetrator and the defendant who is on trial, and if that similarity is common to a limitless class of persons, the evidence has no probative value and must be excluded. Number two, regardless of how many and how striking the similarities a piece of evidence shows as between the perpetrator and the defendant, if that evidence reveals a single dissimilarity between the perpetrator and the defendant, that evidence should not be left to the trier of fact as evidence of guilt, rather should only be left with the jury as evidence potentially showing innocence. There are resources in existence to help criminal defense lawyers learn and know how to make these applications to exclude evidence happen. The first, and this is a must, is Expert Evidence in Criminal Law, the Scientific Approach by Alan Gold. Buy this book. It's published by Irwin Law. It's a natural starting point for whenever one of these issues arise, and it only costs $55. Go to page 136 to 140, and you have a primer on what you need to know to get started on hair and fiber evidence, and you can move forward from there. Own a copy of this well-worn copy of the Kaufman Commission report. It is useful far beyond the facts of the Moran case. It applies to a lot of general principles. Even if you have a hard copy of the Kaufman report, go to www.attorneygeneral.just.gov/english/about/pubs/Moran, and you can download the entire report in PDFs, chapter by chapter, onto the desktop of your computer and cut and paste from it whenever you want to write a factum that includes some issue from it. Hire your own expert, even if you only need to consult with that expert. A hair and fiber expert that I used in a recent case from Illinois, Richard Bisbing, is a good suggestion. He's at McCrone & Associates in Illinois and will do this sort of work on legal aid type of rates. Give him a call, BISBING, telephone number 630-887-7100. Finally, there is one point I want to quickly make about what happened in Bennett and Portillo that's a little bit different than what happened in Moran. There is, in both of those cases, some evidence of hairs that were DNA tested. In both of those cases, the argument that the Crown advanced was that because the DNA hairs matched the defendant, other hairs that were similar to those of the defendant, but also might have been those of a limitless class of individuals, were more likely to have come from the defendant. The logic is difficult to understand. Remember that in Portillo, something that doesn't make it into the judgment is that Noe Portillo, the accused whose hair was at issue, had hair that was dyed with a very unusual type of dye, and that was on the DNA tested hairs as well, and that's probably why that logical link was made in that case. Otherwise, all that inference is, in my respectful view, is a forensic comb-over, using the good hairs to hide the bad. I think my 6 minutes are up. Thank you very much.
I'm going to ask John Norris to come and speak to us about Cass against the Crown.
The idea of the state being made to pay money to our clients is always an attractive one, and it's made even more enticing if there's some prospect of that money ending up in our pockets. But I'm afraid that I have to throw some cold water on that idea. And if your great passion in life is the pursuit of costs against the Crown, then you're definitely in the wrong line of work. As I mentioned in my paper, Phil Campbell contributed an excellent summary of the law as it stood in 2001 to this program. What I tried to do in my paper is bring it up to date because there have been a number of very significant developments since that time. The most important of those developments is what I'll call the numbered company case from the Supreme Court of Canada. The full number is in the paper, and I won't bother to give it to you now. What that case very helpfully does is settle pretty much all of the jurisdictional questions that had been boiling around in the law around who can order costs against the Crown in a criminal or indeed even in a quasi-criminal proceeding. Those issues are now settled, and they're settled in favor of a very broad class of tribunals, including obviously criminal trial courts, as having the power or the jurisdiction to make costs awards against the Crown. What is much less clear still, even after the Supreme Court's decision, are the criteria for awarding costs. Despite some obiter comments in the numbered company case, it is still the case that the Supreme Court has not directly addressed the criteria for ordering costs against the Crown in a criminal proceeding. That having been said, it's clear from some comments from the Chief Justice that some of the criteria that have emerged from case law in the lower courts, indeed very restrictive criteria, are viewed with some favor by that court, and I think we can expect that when the issue finally gets up there, these very restrictive criteria will be endorsed. The restrictive criteria create a very high threshold for a successful application for costs against the Crown, even on the basis of a breach of the Charter. That's probably fairly easy to understand when we look at some of the governing principles in criminal proceedings, and I've tried to set out these principles and given you some of the authorities in the paper. Among the principles that are cited for this high threshold are that the Crown prosecutes in the public interest and not in the pursuit of any private or individual interest, which distinguishes the Crown, of course, from most litigants before the courts. A second factor is that the Crown neither pays nor recovers costs in a criminal proceeding, and that latter idea can be very important for our clients in many circumstances because it would be nothing but to add insult to injury to make them pay for their own prosecution once they've been convicted. The third factor that tends to argue for a very high threshold for such orders is that under the Charter, many other remedies are available and are fully effective to remedy the breach. And I don't think anyone in this room would say that an award of costs would be an acceptable substitute for a stay of proceedings when there's been a breach of the right to a trial within a reasonable time. Nor would anyone suggest that an award of costs was appropriate as an alternative to the exclusion of unlawfully obtained evidence. So the remedies available under the Charter will tend to displace the need for any further remedial relief. As a result, costs orders against the Crown are very few and far between. There are some notable exceptions, but I'd have to say that the early promise of a case called Pulowski from our Court of Appeal, which is cited in the paper, has really not been realized. The corrective function of cost orders has become predominant. That is, it's meant as a sanction against the Crown, to punish the Crown for conduct that is simply unacceptable in the prosecution of a criminal matter, and the compensatory function of cost orders has really taken a very distant second place. I can make some suggestions about how we can try to improve the law, how we can try to push it forward, as indeed it is our obligation to do, and I'll make only three in this context. The first is that the law has developed with specific reference to failings of the Crown with respect to disclosure, failings of the Crown to live up to its obligations to provide proper disclosure as required by the Charter. It may not be the case that the principles that govern there are going to be naturally and automatically applicable to other types of charter breach that can be laid at the feet of the Crown. And so one must be cautious about simply accepting that those principles in the disclosure context will always apply in every other type of charter breach. The second point I would urge you to argue is that cost orders can be a very important complement to other types of charter relief. And the Logan case that is cited in the paper is a valuable illustration of that, because Mr. Logan was successful in obtaining a stay of proceedings at a retrial, but the court awarded him his costs, the costs that were incurred in bringing that application for the stay of proceedings. And that, while it did turn on a disclosure problem, is a view that is potentially of much broader application. And the final point I would make is that we must all be diligent in ensuring that appropriate standards are applied to the conduct of the Crown. The test is whether the conduct of the Crown falls below the standards that we would fairly expect of every Crown attorney. And it's our duty to ensure that standards that are applied to the Crown are fair not only to the Crown, but also to all of our clients. Thank you.
We have the benefit of the presence of a family lawyer this morning, and I'm going to introduce Brian Smith next, who's going to talk to us about some of the issues that arise when criminal law and family law intersect. Brian.
Thank you, Andrea. I feel a little like a rose amongst thorns here today, and I now know why when my clients walk into my office, having come from the criminal lawyer's office, they look like they do, and they're so scared. In my paper, I say that the charges in family cases have significant effects. That's probably a great understatement. The most important effect it has is on custody and access rights, which I'll address. First of all, I'd like to talk about the rare case where the parties want to try to get back together and reconcile. And the difficulty with the attempt to reconcile is that the bail terms usually provide that the parties are not able to communicate directly or indirectly. So people like me find our bag of counselors, we reach into it, and we send them off for marriage counseling. Well, most people think that the marriage counseling is protected and privileged. It is not. The Court of Appeal, in a case called Pabani, stated that the Crown was at liberty to admit evidence of what was said by the husband during marriage counseling because the marriage counseling had not been arranged pursuant to Section 10 sub 5 of the Divorce Act. That section requires that the marriage counseling be done in the context of an existing divorce proceeding, and also that the counselor be appointed by the court. I can tell you that in doing family law for 16 years, I have never, in my practice, arranged marriage counseling through a court order. It never happens, so most family law counsel are proceeding on the assumption that what their clients say at the marriage counseling is not going to be admitted into court, and it can be. From a family law perspective, I can tell you that while it may be admissible in a criminal court, the family court will not allow that evidence to be admitted, regardless of the Pabani case. The other interesting point is that the Divorce Act, of course, only applies to people who are married. So common law persons who go off to marriage counseling have absolutely no protection of the evidence being used in a criminal proceeding. With respect to custody and access matters, our courts still follow the decisions of the late 1970 cases of our Court of Appeal in Kruger and Baker, which basically say that custody will only be granted jointly to the parties if they can cooperate and get along. If you bopped your spouse in the head, chances are you don't get along very well, and the court is not going to grant you joint custody. The effect of not getting joint custody doesn't make a great deal of difference on the monetary awards, but it presents tremendous problems in the long term because it empowers one party. So the child issues are resolved very quickly or early on a practical level if there have been cases or charges of domestic abuse. They also dovetail into the CAS system, and if the criminal charges aren't bad enough, the involvement of CAS in a family law matter is a complete and utter disaster. Many of the jurisdictions now have crossing reporting between the police and the CAS. If there's a domestic assault charge, they will contact the CAS, and the CAS will launch an investigation. The CAS will sometimes require the parent who has control of the children to not allow access to the other parent without a court order, and they threaten to take the child or apprehend the child if the access is permitted. So that leaves typically the wife who has been assaulted in a really untenable position. Many of them feel that their partners are good parents and should still have contact, but they're being told by the government CAS, don't allow contact. They withhold contact, father brings a motion, then we get into supervised access. Supervised access is as much of a disaster as anything else. There are very few supervised access centers in this province. Those that do exist charge a fee, and the person who is operating under a system in the criminal and family law system is already in trouble because he's paying one of you good people for your good services, one of my team for our services, and now he's having to pay out for supervised access centers. The children dislike going to supervised access centers. They are monitored, their visits are monitored, notes are taken, and typically teenagers won't go to them because they have to sit there for 2 hours with their father, typically, and watch the paint dry. So it doesn't work. One of the things that criminal counsel can do to help us as family law counsel is help with bail terms. Now, I appreciate that most of the time when the client walks into your door that the bail terms are already set, but often the bail terms are varied or amended even before they get to the family law lawyer. I think there are two things that you can add to your bail terms to help us out. One is if the children are older, see if you can get the Crown to allow the parent who has been charged to contact the child by the child's cell phone number. Most kids have their own cell phones. If they don't, have your client buy a cell phone for the child. It's better to pay the $30 or $50 a month than it is to pay me to go and get them access. Then they can arrange their time, pick up and drop off with the child directly, assuming it's permitted in the family law matter. The other thing is email. Why shouldn't the parent be able to email their child if they're old enough? And that creates a record so everybody knows what is said and done. There's a couple other things in the paper which I don't have time to deal with. I want to bring to your attention that we are passing new rules in the family law system effective as of July 1st of this year. We are no longer governed by the rules of civil procedure. We now have family law rules. We do not have discovery anymore. We now have questioning. That means that the questions that we ask on discovery are now questions we ask on questioning. And for you to be able to use them, you need to follow within the exceptions of rule, I think it's 25 of our family court rules. And basically it says if the questioning gets referred to in court on a motion, then it can be used in other proceedings and for other purposes. What you need to do is to make sure that the family law counsel either appends the transcript or parts of the transcript to their factum so that becomes evidence within the family proceedings, and then you can have use of it. Thank you.
Just to give you an update, Scott Fenton's had a family matter arise this morning and won't be with us. And hopefully we will be receiving a paper from Scott dealing with the preparation of an effective Section 11B application. I'm going to call now upon Marie Henein to come and talk to us about character evidence on behalf of the accused, and when and how you should put your client's character in issue.
Do I get Scott 6?
No. Don't get Scott 6.
Nice try. Nice try.
All right, in 6 minutes, what I want to talk to you about in terms of character evidence is under these topics: why, how not to, and what if. So let's deal with the first one, which is why. That is, why bother with character evidence at all? Bad character evidence is presumptively inadmissible, generally because of the proposition that while disposition evidence may be relevant in some cases, in most cases it's not. The theory being that because somebody has done something bad in the past does not necessarily mean that they will behave badly in the future. Limited probative value. Interestingly enough, when it comes to good character evidence, that line of reasoning, which serves to exclude bad character evidence has the effect of admitting good character evidence. The theory being that good character evidence is relevant because if you're a good person, you're more likely to be credible and you're less likely to have committed an offense. That stems from ages ago when cases were proven by comburgators. In other words, people would introduce 50 people to come and say, this person is such a good person, I swear on oath they would never commit this crime. So that vestige has survived. And you should know that the courts of appeal are sort of targeting this area as an area that's not logical and may be subject to some attack and some watering down. And we see it a little bit in sexual assault cases. I'll talk about that in a few moments. So why bother? You bother because at the end of the day, you can go to the judge or the jury and ask them to consider the good character evidence because A, it supports the credibility of the accused, and B, it supports an inference, more importantly, that your client was unlikely to have committed that type of offense. So let me move now to how. What type of offense is admissible when you're trying to introduce good character evidence? The rules are very, very clear on the type of evidence you can introduce. The most common type that we're used to in the first category is that witnesses can testify about the accused's general reputation in the community. You should know that community has been very broadly interpreted as a matter of law by our Court of Appeal to include not only a person's neighborhood, not only their social community, but very distinctive communities, such as a distinctive cultural community, or more importantly, a business community. So that if you've got a guy that's charged with fraud, introducing good character evidence from the business community is something that may be particularly relevant. So when you're choosing which witnesses to adduce as good character witnesses, you've got to pick your character witnesses very wisely. You cannot ask your good character witnesses to testify about specific acts of good behavior. That is not permissible. In other words, you can't say to a witness who testifies, can you give me an example of why you think this person is such a good person? Or when your witness comes up and testifies, let's say on a sexual assault involving babysitting, you can't have your witness say, you know, this guy's babysat my kids all the time. I would trust them with him without question. Not allowed. Only general reputation in the community. How do you get around it a little bit? This way. Well, you can't say, does the accused babysit your kids? You can call a parent of children that your client has babysat, for example, and ask them this question. How do you know the accused? Well, I know them because he's babysat my children. And what's his reputation for honesty, integrity, blah, blah, blah in the community? So you backdoor it that way, and you're setting the framework as to how they know this person. That's entirely proper, not specific acts of good conduct. Second way you can introduce it is through the accused. Unlike general character witnesses, the accused can testify about specific acts of good character. They can recount all the sort of wonderful things they have done in their life. They can do it, whereas a good character witness cannot. Ways they do it is by saying, I'm not that type of guy. I babysit kids all the time. I work with children. I've never hurt a fly. I'm the most honest person on earth. Those sorts of things your client can say and give specific examples, and there may very well be, that are relevant. So out of the client's mouth, specific acts are admissible. The third category, which we don't have time to talk about, is expert evidence, arising from Mohan and those lines of cases where you're adducing expert evidence to show that your client doesn't fall within a distinctive group of people that are more likely to have committed the offense. For example, pedophiles. There's a bit of issue about the scope of admissibility, but at least keep in mind that expert evidence can qualify as good character evidence or putting your client's character into issue. I just want to mention a little bit about good character evidence in the context of sexual assault cases. I said a moment ago, that the rules relating to good character evidence are somewhat illogical, not well grounded, and may be subject to attack. And we saw that dealing with sexual assault offenses, the first frontline attack, in a case called Profit. The Supreme Court of Canada upheld the Ontario Court of Appeal in concluding that good character evidence is of limited value when it comes to sexual assault offenses. What does that mean? Practically, it means that a judge at the end of the day or a jury can choose to disregard it. I'm almost cooked. One more minute. But it doesn't mean that you can't introduce it. So you still can introduce it, and it's sort of silly reasoning, their theory being that good people do bad things in private. Well, I've never seen an accused take a newspaper ad out and announce they're about to commit a crime. Most crimes are committed in private. So that line of reasoning does not mean that you cannot adduce that evidence. It just means it may be of less value. When it's a jury, it may be of actually quite a significant value to you. How not to put your character into issue. Make sure your client doesn't say things like, I'm not the type of guy, I would never do, I'm a peaceful sort of person, or they don't get cross-examined and suckered into putting their character into issue. That is a function of training. And last word, what happens? What if your character is put into issue when you don't want to go there? Very, very bad things happen to nice people. And this is what happens. Number one, the Crown may be able to introduce the criminal record you worked so hard to exclude. Number two, they can introduce general reputation, bad character evidence. It's often hard to get that. And number three, and this is the most terrible thing on earth, they will introduce the similar fact evidence you excluded. Because when you argue that it was not probative and you excluded it at the front end of the trial because it had nothing to do with what you were leading, and your client kindly says they're not the type of person, probative value increases, and now it comes in through the back door. So be careful and train your client not to do that to you, because you'll have a very bad day. Thank you.
Thanks, Marie. If I can call on my partner, Andrea Tuck-Jackson, to talk to us about Little. Just a little.
About Little.
Just a little bit about Little. Not a lot.
I get the hint, Peter. I want to talk to you today about a very basic rule of cross-examination. And that rule is the product of a question that was considered by the Supreme Court of Canada in the recent decision of Little and the Queen. And the rule, as expressed by the Supreme Court, is as follows. A question can be put to a witness in cross-examination regarding matters that need not be proven independently, provided that counsel has a good faith basis for putting the question. And we're going to call it the good faith basis rule, because that's the most important turn of phrase you're going to have to remember. Let me put the rule in another way. When you are cross-examining a witness and you put a suggestion to the witness, the Supreme Court is telling us that you are not, by putting that suggestion to the witness, you're not undertaking to call independent evidence to establish the point that you're trying to get that witness to adopt when the witness chooses not to adopt it. Okay? Now, in order to illustrate why we have the rule, I'll give you a bit of an overview of the facts in Little. Mr. Little found himself charged with a variety of serious offenses, including robbery, assault, kidnapping, and possession of a weapon. And those charges arose as a result of a very vicious beating that was alleged to have been perpetrated by 5 individuals, 4 of whom were masked, and unfortunately poor Mr. Little was the man who was unmasked and was ultimately identified in a photo lineup by the victim. The victim claimed to the police that he had been beaten over the theft of a gold chain. A detective who was initially assigned to the case took a detailed statement from the victim and questioned his credibility, because there were 2 aspects of the account that caused him concern. One was the severity of the beating, having regard to the value of the gold chain that was supposed to be the subject matter of the beating. And secondly, the officer found it very curious that the victim had a conviction for drugs, drug trafficking, as I recall. The officer reduced his concerns to an occurrence report, which was ultimately disclosed to the defense. Now, at trial, the defense wanted to advance the position that the attack indeed had nothing to do with the theft of a gold chain, but instead that Mr. Barnaby, who was the victim, his beating was related to an unpaid drug debt, and that Mr. Barnaby had fingered Mr. Little as his assailant in order to protect the real offenders who the defense theorized were his associates in a drug ring. Defense counsel did not want to have to call any independents to prove or to establish this theory. Now, pausing for a minute, you might want to ask why. Why, if you're going to put a proposition to a witness, wouldn't you be enthusiastic about leading evidence to substantiate the proposition? Well, there are two good reasons why you may not, and they're grounded in tactical decisions. First of all, you may not want to do so because you may not want, when you're in front of a jury, to have to call a defense, because you want to have the benefit of addressing the jury last. Secondly, it may be that the witness who provides you with the evidentiary foundation for this wonderful suggestion is helpful on that point, but it may be that he or she has devastating evidence that hurts you, and accordingly you don't want to throw that person up in the stand and open them up to cross-examination by the Crown. So there are good reasons why you don't want to necessarily have to undertake to call that evidence. What then are the criteria that you must satisfy before you can put a suggestion to a witness with the confidence that you're going to meet the good faith basis test? There are 5 points I suggest you have to bear in mind. First of all, the question obviously must be relevant to a material issue before the court. Secondly, the evidence sought to be led must otherwise be admissible. Thirdly, the suggestion must not be known to counsel to be false. Fourthly, the question must not be put to the witness recklessly. In other words, you can't put the suggestion to the witness with reckless abandon. And finally, and this is the one that I'm going to ask you to bear in mind the most, the suggestion that you're putting to the witness must be honestly advanced on the strength of information known to counsel, a reasonable inference, and experience and intuition. What does that mean? Well, that means that if, having regard to information you've gleaned from disclosure, from the preliminary inquiry, from witness statements that you've taken, from information you have received from your client, if you take all that into consideration, you apply common sense by drawing reasonable inferences from them, and you apply your own sense of experience. If you can honestly convey to yourself and satisfy yourself that there is a good faith basis for putting that proposition to the witness, then I suggest that you're on good footing to do so. Two other comments that I want to make about the Little decision. I suggest that you read it carefully. There's some excellent language in it regarding the value of cross-examination, which you may want to import into other cases and in other contexts. And secondly, there's also some useful language in it as to the fact that the traditional rules of engagement which arise during the course of a trial can be relaxed when it is a defense lawyer as opposed to a prosecutor on his or her feet. Thank you.
Thanks, Andrea.
I'm going to ask Janet Leiper to come up. You remember Janet normally sings for the 6 minutes, but this morning she's told us that she's got a raspy voice, so she's not going to sing. She's just going to speak to us about how to read Disclosure Part 1.
Dante's Divine Comedy, written 700 years ago, bids its readers to find fruit in your reading. Defense lawyers spend a lot of time asking for, reading, and analyzing disclosure. In essence, looking for fruit. So here are 4 pieces of disclosure wisdom from Dante's Inferno. Canto 13, line 135, The Divine Comedy. I have seen a ship sail swift and straight over the fast sea, through her entire course, to sink at last while entering the harbor. If the proof of the ship is in completing the journey, the proof of fairness is in providing full disclosure when required. In recent years, we have been asked to accept most, a good deal of, or enough disclosure as defined by the Crown, if you like, disclosure by percentage, and to proceed to take steps like set dates, hire experts, or even show up for our trials without full disclosure. Faced with only part of the story, remember the case of Regina and Periniac, site is in the materials, where Justice Lowe said the standard is full disclosure because what is sufficient cannot be measured in the absence of seeing the totality. That which is withheld may be sufficient to alter the plea or the election as to the mode of trial. From Canto 17, a triangle cannot obtain 2 obtuse angles in it. By press release dated February 27, 2004, the Department of Justice proudly announced on a priority basis draft amendments to, quote, effectively implement the charter-mandated obligation of the prosecution to disclose all relevant information in its possession to an accused. Now you know a second obtuse angle is coming when the government announces changes to legislation dealing with a constitutional right that's been in place for over 10 years. And sure enough, one of the draft proposals is to create a concept known as core disclosure, which would not include all relevant material, but would cut down on the burden of the Crown copying all of the relevant material. The backgrounder, which is in your materials, suggests that they would eliminate from core disclosure documents about which it says, quote, a significant proportion of these documents could be of marginal relevance and of no assistance to the defense. Obviously, some of them might be of real assistance to us, but they're not going to give them to us. We'll have to go to a station, or we'll have to travel somewhere, and we'll have to pay for the copying. So the 2 obtuse angles here. 1, amend the code to effectively disclose all relevant information to the accused. 2, let's make it more difficult or expensive for the defense to obtain all relevant material. And how were these proposed changes brought to the defense bar in Toronto? Environics was hired to conduct a focus group in a dismal high-rise. I went at the end of a long day. No justice officials attended. A professional moderator asked a series of questions. I think the first one was, what does everybody here think about disclosure? Somebody taped the discussion from behind a one-way glass. The result? A not-so-polite revolt. All of the participants agreed the proposals were highly problematic, and 2 of the participants declined the offered $200 honorarium and invited the Department of Justice to spend it on fulfilling its disclosure obligations. Canto 13, line 115. For often it occurs that one's opinion, when quickly formed, leans in the wrong direction, and vanity then binds the intellect. This truth is at the heart of 90% of disclosure problems, and the failure of prosecutors and police officers to intuitively understand relevance in any given case. Remember that dope sheets do not arrive with a list of possible defenses on the front. Cases often get distilled by the prosecution side into crudely described morality plays. And remember that police officers do not view making disclosure as one of their core functions. At best, it's a necessary prerequisite to moving the case forward, and at worst, it's a carelessly performed task of low or nil priority. Where does the arrow end up pointing? In Giramonti and the Queen, the Court of Appeal points it at the prosecutor in law, who has to make the initial determination of relevance and disclose what is relevant. But remember, relevance is broadly defined. The Supreme Court of Canada in Egger talked about usefulness to the defense. And so often, the persuasive arrow swings back to us. Because who best understands usefulness to the defense than the defense? It may not be our burden in law, but sometimes it's the correct decision to explain the relevance of something that you want to the Crown and the police, maybe more than once, in order to preserve later remedies. And as for the Crowns, all I can suggest is that they read John McMahon's paper from a few years ago at the Federation of Law Societies entitled, "When in Doubt, Give It Out." I will conclude appropriately then from Purgatorio, Canto 9. Disclosure Purgatory. As a man in dismay feels reassured, his fears resolving into resoluteness when truth at last has been revealed to him. Here are some final truths about disclosure. An accused person need not trade off his disclosure rights to ensure his speedy trial rights. There is a long line of cases, some of which appear in your materials, which make that clear. The current fashion in police and prosecutorial circles is to blame defense requests for disclosure and delays, rather than addressing in a systemic way ongoing problems with timely disclosure that rest with them. This fashion is translating into potential legislative reform, which may pose a threat to fair trials. And finally, Mr. Stinchcombe, who returned for a retrial after the Supreme Court of Canada used his case to educate the bench and bar about the importance of disclosure, did not stand trial. You want to know why? I quote the prosecutor. "The ability of the accused to make full answer in defense has been seriously affected by the passage of time, the history of the case, and current disclosure difficulties." We are truly in purgatory. Thank you.
Thank you, Janet. I'm pleased to say that we're very ahead of schedule, but we'll break now for 20 minutes and we'll reconvene at
25 to.
10:35. Thank you.
You'll start.